Furthermore, they mutually agreed that they will be creating a software mind play. Now, the agreement was very much smooth sailing until it unexpected block due to and solely the actions of the respondent. When the respondent CEO, by
What
giving
is the background of the parties?
the background of the party, indeed, Mr. Operator, AI innovations come from a country called Robo Nation, and they are thriving experts in the field of AI. And moreover, Indovia comes in. Application comes from the country of Indovia, which is similar to the country of India, as their laws are pari material to the country of India. If the arbitrator is satisfied with the facts of regarding this particular question, I shall continue the facts. Now, the respondent, as I was saying, the respondent CEO, while giving an interview to a popular magazine, had overlooked and grossly overlooked the efforts of the claimant in the development of Mindclear. Now, the claimant was very much aggrieved by this action, rightfully so. As a result, the respondent offered a solution to release a statement to rectify the issue. But soon we would know that this was another malicious attempt of the respondent, as when they released the statement.
But tell us, after how many days of entering into agreement, he made this announcement?
Indeed, Mr.
And what was the progress by that time?
Indeed, Mr. Arbitrator. Mr. Arbitrator, the agreement was entered into March 15. March 15 was the time when this party entered into an agreement. Furthermore, this particular interview was on June 30. That is the emergence of the first dispute on June 30. If I may continue.
Yes, sir. So agreement was dated
March 15
and the statement was given
on June 30.
June
2020.
So what was the development which has taken place within these 5 years? What was the progress?
Both the parties in this particular block, when the respondent CEO, while giving an interview, overlooked the efforts of the claimant in the development of Mindclear. Now, after that, they to rectify the issue. As per their words, to rectify the issue, they released a statement in which they refer to us as a mere technical support partner. Now, the mere technical support partner, the claimant believes is a diminishing, is not an accurate representation of the claimant. As a result, the claimant had communicated with the respondent, but the respondent did not give any proper rectification. As a result, the claimant had no option but to invoke arbitration under the CR. Now, furthermore, the CR had appointed Ms. Erica Sinclair as an chairman to the arbitral tribunal, and the respondents alleged that the arbitrator had connections to the claimant, but the claimant had nowhere.
But before jumping to that third arbitrator and the chairman were appointed, kindly why the two arbitrators could not agree to appoint a third arbitrator, the chairperson?
Obviously, there are conflicting disputes between the parties. That may be one of the reasons why they couldn't agree upon a third arbitrator, and hence CR allows for a provision where a third arbitrator can be appointed. And furthermore, the dispute resolution clause itself provides for that in case both parties cannot agree for a third arbitrator, CR shall appoint it, which I'll be stating, which is mentioned in 25.4 of the collaboration agreement. Resolution clause 25.4, which reads that the third arbitrator, irrespective of the method of appointment, shall not be as the same nationality of the parties of collaboration. If the two party appointed arbitrators cannot agree upon the appointment of third arbitrator, they shall be appointed by the CR.
So who is aggrieved by the appointment of the chairperson?
Sorry, Mr.
Which party is aggrieved by the appointment of the chairperson?
It's the respondent. It's the respondent.
You have no objection?
We have no objection. We believe that Ms. Erica Sinclair is a neutral party to the proceedings. Now, if the arbiters, okay. Furthermore, there's one major issue also. The respondent, while during the arbitral hearing, produced a controversial print screen wherein it contained information regarding communication between the CEO of the claimant and the legal team of the claimant. Now, for anyone with basic understanding of laws, knows that this defies the very principle of legal functioning. As according to various common law, the communication between an attorney and a client is of utmost secrecy. Now,
one question. By the time you invoked the arbitration clause and started the proceedings, was this mind player completely completed? That project was already completed, or during in between itself you had fallen out with each other and started the arbitration proceeding?
It was still in development.
So it was not yet complete. Project was still going on.
Yes, sir. It is still under development.
And as per the agreement, within how much time period the project was to be developed?
there were specifications regarding the time constraint and how it
Show
should.
us where in the agreement it says that
Yes.
within how many
Yes.
periods it was to be developed.
Yes, Mr. Arbiter, I was about to get to that, but it has not been specified in the board proposition. There have been paragraphs stipulating that there have been set time precedents regarding when it should be completed, how it should be completed.
Anyway, the project was not completed.
Yes, Mr. Arbiter.
Okay.
Mr. Counsel, there was a pre-mandate to arbitration, right?
Yes, Mr. Arbiter.
As per mandate of 25.1. So was this mandate adhered to you?
Mr. Arbitrator,
Because I'll share two dates with you. The first date was 10/10/2022. That was the letter, that was basically an attempt by the respondent to enter into negotiations with you. And 15th of November was when invocation notices were issued by you for invocation of the arbitration clause. As per the mandate of 25.1, there was a period of 45 days that was to expire, post which you could have invoked the arbitration clause. If we take 10th of October as the date when negotiations were started, that date would have ended on, let's say, 24th of November, and post 24th of November you would have been in a position to invoke the arbitration clause. Is the invocation not premature? And if not, why?
I would like to answer this question in two parts, Mr. Arbitrator. Firstly, as per the moot proposition, it has been established that the claimant was the one who was trying to make an amicable resolution, and multiple attempts were made by the claimant, but there was no proper rectification provided by the respondent.
Just pause here for a minute. If you're saying that the attempts were there, there was a mechanism that was to be adhered to by any party who wanted to enter into negotiation. That mandate was specifically laid on in 25.1. Was that followed by you in letter and spirit? Or was it a general negotiation that you were trying to, let's say, execute with the respondent?
Mr. Arbitrator, yes, we have indeed abided by 25.1 because there had been previous negotiations between the parties regarding the particular timeline. And more further, I would like to mention the timeline. The timeline to set the negotiation, as you mentioned, was 45 days. The first emergence of the issue was on July 11th, and the parties, the claimant, invoked arbitration on November 15th. Now that is more than 60 days, which has obviously bypassed the clause which says 45 days. As a result, the pre-mandated of arbitration we have actually complied with. Mr. Arbitrator, if I may proceed to my next submission is that as we were talking about this particular clause of negotiation, clause 25.2 states that in clause 25.1, which talks about the method to resolve the dispute phase, dispute shall be governed by intervening courts exclusively. However, clause 25.3 mentions that notwithstanding the provisions of clause 25.2, which indicates a bypass clause to 25.1, as a result, bypass clause 25.2, as a result, the claimant is eligible to approach the CR under this particular dispute resolution clause.
Without exhaustion, without adherence to 25.1 or 25.2.
With other risks, we are contending that we had participated in the negotiation proceedings, as is mentioned in the proposal. The council would like to state the case of National Agriculture Corporate Market Federation versus Jnmc Limited, which has been mentioned in page number 7 and 8 of the complaint that has been submitted in front of the arbitral tribunal. In this case, the Supreme Court held that the arbitration clause is an independent clause of other terms of the contract, and even if the agreement is nullified, it wouldn't make the arbitration agreement within it ipso jure nullified as well. Now, this establishes the principle of doctrine of severability, which is a long-established principle since the beginning of arbitration. Now, as per the municipal model law, Article 16, an arbitral clause which forms part of the contract shall be treated as an agreement independent of the other terms of the contract. As a result, this particular doctrine is upheld in this particular case. If the council is, if the arbitral tribunal is clear with the facts of the first issue, I shall move to the second issue. Much appreciated, Mr. Arbitrator. Mr. Arbitrator, before moving on to the second issue, I would like to state one more case, which is Divira Distilleries parent versus Divira Distilleries subsidiary, in page number 2 and 3 of the compendium. In this case, the question regarding whether we should adhere to the pre-negotiation part has been answered, where the Supreme Court itself has said that premature invocation of arbitration did not merit any serious consideration. Rather, the exchange of communication between the parties was mere formality, as it didn't show any particular resolution. Now, moving on to the second issue. The challenge raised by the respondent over Ms. Erica's appointment is not maintainable. The council humbly submits that the timeline to challenge Ms. Erica's appointment has been over. For that, the council states Rule 15.1, which is mentioned in page number 35 of the compendium.
And what is their challenge? Why they are challenging? Why they are aggrieved by your appointment?
Mr. Arbitrator, the respondent claims that the claimant has a relation with the arbitrator in this particular case.
What is that relationship?
It is an indirect relationship from the perspective of the claimant. The arbitrator's husband, which is Mr. Murray Sinclair, is chairman of board of a company called Jnmc, which holds 99% of another company called Algorithma, which holds another 57% of the claimant's company. Thereby, it is clearly established that it's an indirect relationship in terms of the relationship between the parties and the arbitrator. Furthermore, this comes under the waivable red list of the IBA guidelines, and even more in the case of Avital, was it Avital
But
Limited?
you are for the claimant, you are not aggrieved by her appointment.
Yes, we are not agreed by the appointment. If I may cite the case of Avital versus HSBC TI Holdings. In this case,
Is it there in the
we do
compendium?
have the submission present over here regarding the full judgment. So in this particular case, there were allegations regarding fraud, misrepresentation, and even biasness of the arbitrator. And even then, the foreign award that was declared in this case was upheld by the court. Now, even more further, the IBA guidelines, like I stated, was upheld in this particular issue, and the judge even mentioned that.
What is page number?
Mr. Arbitrator, I have the judgment over here. I haven't provided the judgment.
Is it that compilation is there?
Yes, it's not.
Page number?
It's not there in the page compendium. Sorry, Mr. Arbitrator. If I may submit the. The excessive disclosure unnecessarily undermines the confidence of parties in the process of arbitration itself. This is what was held by the court in this particular case. I would like to submit the particular judgment.
Just indicate which paragraph.
I have mentioned it. I'm not sure which paragraph it is. If I may.
Is it not?
Sure.
Okay, we'll ignore it. We are running short. Yes.
Mr. Arbitrator. Thank you, Mr. Arbitrator. Now, the council would like to state the case of Hannock versus Hannock Prospecting Limited, in which similar fact was there in this, as per the particular case. In this, the arbitrator's spouse, which is the arbitrator's wife in this case, had counseled the party, one of the parties in the arbitration agreement. But this did not merit any serious consideration once again, and the court upheld the appointment of the arbitrator under this particular case law. Now, moving on to my second sub-issue is that the claimant had no part to play in appointment of Ms. Erica Sinclair. The council maintains strong conviction that Ms. Erica Sinclair's appointment was purely done by the SIAC, and SIAC is an established institution known for its trustworthiness and reliability. Even more further, clause 25.4 of the collaboration agreement, it states what shall not be done in case of appointment of arbitrator, and it states that an arbitrator's appointment may only be challenged on the basis of its nationality, and no other condition has been mentioned. And even when the respondent had the opportunity to inculcate such a provision into the contract, they didn't do so. So they shall abide by the undertakings they willingly undertake. If the bench is clear with the facts, arguments of the second issue, I would like to proceed with this.
Just one query. Isn't that application of 12, section 12, read with schedule 5 and 7 will have no application in the present matter?
So, arbitrator, if you can repeat the question, I can.
So your contention is that the rules of Singapore International Arbitration Center will have applications, so that means the operation of section 12 subsection 1 read with schedule 5 and schedule 7 will have no application as far as the appointment of the arbitrator is concerned.
See, we are talking about the Indian Arbitration Act of 1996.
1990.
Under section 12 of that act, the
Section 12,
person
read with schedule 5
arbitrator
and
has
6.
an obligation.
12.1.
Yes.
12.1. And you have 12.1 and read 12.1 with 5 schedule 5 and 6.
Moreover, he has an obligation to disclose his own interest. Before entering into arbitration, he should disclose his own interest in the arbitration, so as to give an opportunity to the person opposing his appointment. So, is there an obligation under this procedure for him to disclose his relationship with the
Sir is
claimant?
trying to ask whether the disclosure by the arbitrator, by the chairperson has not been made, that she has no association with any of the parties.
Firstly, Mr. Arbitrator, the information regarding Ms. Erica Sinclair was available on a website, and this was known to the respondent in.
And we have 12.1 for minute, please. Section 12 to section 1.
It is the duty of the arbitrator
And we
to
have 12.1.
give a declaration.
12 subsection 1. When a person is approached in connection with this possible appointment and asks an arbitrator, which are disclosed in writing and circumstances such as existence.
So therefore that
Yes.
means the statute provides an obligation upon the arbitrator itself It is immaterial that that information may be available in the public domain or not, but it is obligatory upon the arbitrator to. Now, my question to you is that you have made an argument that, as far as the appointment is concerned, the rules of SIAC 2016 will have application. So that means, does SIAC overrides the mandate of 12.1? Very specific question to you.
Mr. Arbitrator, like I stated the first part of your question regarding the disclosure by the arbitrator, I had cited the case law as HSBC was evident, most evident, in which the Supreme Court has itself, and the court has itself has said that the excessive declaration by the arbitrator may be threatening the integrity of the arbitration proceeding as a whole and the confidence of people in the arbitration proceedings. Even more further, even now we only have established allegation regarding that Ms. Erika Sinclair might be impartial or there will be lack of independence of Ms. Erika Sinclair. She hasn't acted upon the particular issue, and as a result, like I stated, the case of Hannock was Hannock Prospecting Limited. Similar circumstances were there, where the arbitrator's wife was the legal counsel for the particular claimant, and even that arbitrator's appointment was upheld in the particular case. As a result, the counsel would like to use the benefit of the case laws that has been provided.
Okay, thank you.
Much appreciated, Mr. Arbitrator. Mr. Arbitrator, the counsel would like to move on to its third issue, that is, the claimant has absolute ownership and proprietary rights over the mind flayer. Now, the claimant has incurred major non-monetary and monetary losses due to the actions of the respondent, whereby they undermine the collaboration of the claimant in this particular matter. Now, if you may please proceed to clause 5.1 of the collaboration agreement. It is stated that Artificiana shall provide financial obligations to the claimant in this particular case, as the claimant is the one who is developing the product. Now, it has been mentioned in clause 20.2 of the intellectual property laws that upon successful completion of the project and full receipt of all payments that are due under this collaboration agreement, AI Innovations shall transfer and assign Artificiana all rights. That is, the claimant shall transfer all the rights that it has contained to Artificiana once the payment has been made. But in this particular scenario, the respondent has failed to meet its financial obligation. So as a result, this clause was provided for this particular purpose of safeguarding the interest of the claimant itself. So as a result, this has
What was the total amount which was to be paid to you?
that has not been specified in this particular mood proposition, but the damages we are seeking from the CIAC is $500 million.
Okay, whether no money has been paid or part money has been paid.
They had the clarification regarding that has not been given, but it has been mentioned that the claimant had sent a notice to the respondent 10 days prior to the due date, and even then, since the dispute, there has been no payments made ever since then, and even further. Yes, Mr.
No,
Arbitrator.
please go.
So you are trying to say that since no payment has been made, so the ownership right is still with you?
Yes, as per the clause, it qualifies us to be in ownership of the property.
So, counsel, kindly have 23.2 for a minute.
23.2.
Material breach. There was an obligation casted upon you. If either party commits a material breach of any provision of this collaboration agreement and fails to cure such a breach within 10 days after receipt of written notice specifying the breach, the non-breaching party may terminate the agreement. So in this case, was this non-payment, since the non-payment is a material breach of the agreement, was the mandate of 23.2 ever adhered to you, adhered by you?
The council would like to state that the date regarding when we send the notice for payments hasn't been specified in the board proposition. Thereby the council would like to misrepresent the facts of the case.
The point is, you have not terminated the contract and the project was not completed. Therefore, there is no question of you are having any proprietary right over the mine player.
Yes.
Isn't it?
Yes, Mr. Arbitrator, but the action of the claimant of not terminating the contract indicates a good faith on the part of the claimant. Thereby, we wish to, we were someone who was focusing on the harmony and collective interpersonal relationship of the
No,
parties.
but therefore, your claim for 500 million US damages, fraudulent claims and violating the conditions of contract. So therefore, what were the kind of fraudulent claim that the respondent made about the product ultimately?
Mr. Arbitrator, you are not audible. I'm very sorry, but
No, I am asking you, you are asking for damages for making fraudulent claims. So therefore, what I mean to say is that what is the kind of claims that the respondent made against you?
So what is that statement which was fraudulent?
We haven't mentioned anywhere that it was fraudulent. Rather, it was misrepresented. And the 500 million damages does not include that specific breach itself. It includes a series of breach. One is the accurate representation clause mentioned in clause 5.3 of the collaboration agreement, whereby the respondent had a duty to accurately represent the claimant in this particular case.
So you are aggrieved by misrepresentation or non-payment or by both?
Yeah, all of them, all of the above. All of the above. And as a result, even if the respondent contend that the term technical support partner is accurate, it's not. Because the term support over there, according to Cambridge Dictionary, means, much appreciated, Mr. Arbitrator, the term support according to Cambridge Dictionary means mere assistance. In this case, the claimant can even argue that we had no part to play in the role of making of mind player. And since they are the ones only providing financial obligations, as a result, this was not a true accurate representation. And even more further, they had the discretion to use much better words which would have properly indicated the role of the claimant in this particular issue, but they chose not to willingly, which shows the bad faith on their part.
See, your statement of claim or case shows that you are not so much worried about these, the terms of the agreement, but the statements made by their executive, whereby your contribution was not adequately made public. That was your grievance.
Yes, that is the emergence of the grievance. Then a series of grievances had occurred, even more further, wherein the first was accurate representation and the lack of meeting financial obligations.
These are only two.
Okay.
These are only two, yes.
Okay, you can hand over to your friend now.
If I may sum up with the permission of the arbitrator tribunal.
Okay.
Okay.
Thereby, even clause 20.1 mentions that the claimant is provided with exclusive rights during the development of the project. Now, as the council has stated, the mind player is still under development. Therefore, as the project is still underway, the claimant is the one who is eligible to keep the ownership of mind player. I would like to cite the case of Warner Landmark Company LLC versus Activist Group, which has been mentioned in page 17 and 18 of the compendium, if you may refer to that. It has been mentioned that this case involves a patent dispute in the United Kingdom. It highlights the importance of clear contractual provisions, whereby the method that the contract has been worded has to be clearly used to determine the ownership of the particular parties. Now, this indicates that the contracts are languaged in such a way that it ensures the clear obligations and the roles of parties in this particular context. Now, with the permission of the court, I would like to invite my co-counsel to the dais. Thank you, Mr. Arbitrator. Thank you for your patience.
Permission to approach the point, please.
Good morning. Learned co-counsel has very well explained issues 1, 2 and 3, and I will be dealing with issues 4, 5 and the rest subsequently. If the tribunal, the counsel requests much obliged. The issue 4 states that the respondent is in full conviction of the breach of agreement and the claimant is entitled to receive damages on the basis. The claimant would like to contend from the beginning after the signing of the collaboration agreement that the problems arose after an interview was conducted by the respondent CEO, Mr. Jnmc, who in the interview did not slightly mention about the contributions of the claimant as well. The claimant, according to the collaboration agreement, is the primary contributor in the production of Mindflyer, while the respondent is morely focused on providing the financial contribution to the project. According to the facts of the moot proposition, it has been clearly established that the respondent is a global frontrunner. On the contrary, the claimant is just an upcoming technological company in the market. This actions of the respondent showcase that the claimant wishes to receive reputational damages and irreparable losses on the actions which have been taken by the respondent. On the second, the public statement which the respondent, after the claimant has explicitly showcased his deep grievances on the interview which was conducted by the respondent, states that the public statement by the respondent calls us as a mere technical support partner.
How do you say that you have the intellectual right with you of the product which you are developing?
Sir, can you please repeat the
How do you say that you have the intellectual right with you?
intellectual right to according to the collaboration agreement, the collaboration agreement clearly states the claimant will hold on the exclusive rights till the completion of the project, and if there is a default of payments on the side of the respondent, then the claimant can keep hold of the intellectual property till the receipts of the payments, and the payments have been fully submitted and completed. Then the condition, in this case, this is not the matter, and the product is still in development. As in the moot proposition, it nowhere stands as a product is being fully completed. Hence, the claimant has been challenging for the ownership of the product.
Mr. Counsel, I'll read out issue number 4. Whether the respondent has breached the agreement, thereby entitling the claimant to sue.
Yeah.
What is the aware of the collaboration agreement that has been breached? What is that specific condition? What was that specific obligation that was casted upon the respondent that you say it has been breached as per the collaboration agreement?
Indeed, Mr. Arbitrator, I would like to answer your questions in two folds. The first part, if you look at the collaboration agreement given below, 5.1 specifically states. 5.1 specifically states that artificial shall provide financial contribution as agreed upon between the parties. As the claimant has already mentioned, is about to mention that according to the facts of the moot proposition, the respondent has breached this agreement by defaulting the payments which are required in the production of manufacture. On the second, clause 5.3 specifically states that artificial shall ensure accurate representation of AI innovations contributions. The interview and the words technical support partner, according to the claimant, does not seem feasible that the contributions which have been provided by the claimant towards the development of the project aren't.
Where is that obligation casted in the collaboration agreement?
Clause 5.3. Clause 5.3 and 5.1. Financial contributions and accurate damage.
Okay.
In your claim, do you make any claim towards intellectual property right violations?
We claim according to the proposition, we claim the ownership towards the intellectual property rights of Mindflare as well as $500 million in damages.
No, about the arbitrable nature of the dispute relating to intellectual property rights. What is the legal proposition? Is it an arbitrable issue at all? An intellectual property right under the law?
Mr. Arbitrator,
Sir is saying that the product is still not ready. It is in the process.
It is in the process. Secondly, an intellectual property right is the subject matter of the arbitration. So, is it an arbitrable issue at all?
Mr. Arbitrator, the question which you have asked will be answered in rebuttals as my co-counsel has the exact answers to the questions which you have.
Okay.
Thank you. On the third, the withholdment of financial contributions by the respondent has delayed in the production of Mindflare. The claimant, in accordance, have followed the due obligation in the production of Mindflare and has used the extensive labor which it contains for the production and has not reached the collaboration agreement, even though the respondent has breached it in sense. This has created financial losses and showcases the carelessness that the respondent possesses and neglects the collaboration agreement alongside with the claimant. If the tribunal is satisfied with the arguments, I would like to proceed with the fifth issue. The fifth issue states the print screen which has been produced by the respondent is not admissible at this stage of hearing. The print screen which is produced by the respondent is an email which is a conversation between the legal representatives of the claimant and the CEO of the claimant as well. This falls under the purview of attorney-client privilege, which is also mentioned in section 1.
What is the date of this print screen? Was this prior to the statement by the respondent, or was this prior to the issuance of legal notice or invitation or obligation clause?
Mr. Arbitrator, according to the moot proposition, the date has not been mentioned, but it states that at the hearing of merits, the respondent had produced a print screen. That is the only detail.
Had produced, but what is the date?
The date has not been mentioned in the moot proposition. It is just said on the hearing on the date of hearing.
So you are proceeding on the assumption that it's a privileged document. It's a privileged communication.
Yes, it falls in the purview of attorney-client privilege, and this is a confidential document within the internal communication of the company. It is not a document which has been disclosed outside. So, as I like to continue, it falls under the purview of attorney-client privilege, which is recorded even in Section 126 of the Indian Evidence Act, and would like to also state the IBA guidelines, which is the International Bar Association guidelines on taking in of evidence in international arbitration. Under this, in Article 9, which specifically talks about admissibility of evidence and assessment of evidence.
But before you proceed, kindly tell us how you are aggrieved by this email.
So, first of all, thank you, Mr. Arbitrator. I would like to answer your questions in two folds. The facts of the case clearly show that the respondents have reached a collaborative agreement. On the contrary, these guys also the respondents.
My question is only for the email. Print is free.
Yeah.
How you are aggrieved?
The print screen is actually irrelevant to the case, and it deprives the process of natural justice if it's admissed in the court of in the arbitral tribunal. According to the case of Aruna Baru versus Union of India, which is held by the Apex Court, that states that which explained the concept of clean hands, which is that the party should not approach the court with dirty hands and suppress the material facts. According to
So what is clean and what is dirty in this email?
It is a confidential document, Mr. Arbitrator. Firstly, it's a confidential document. Secondly, it is an internal communication between the legal representatives and the CEO of the company, which falls in the purview of attorney-client privilege. In the concept.
No, here the problem is it is not an outside attorney. It is your own internal team. It is a company's own employee. The attorney who is advising you is not an outside lawyer whom you are consulting and claiming privilege of communication. You are only saying confidentiality. On the contrary, it is your own employee, your own team, which is advising the chief executive about the legal implications. So or put it on same par with the consultation with an outside attorney.
Mr. Arbitrator, thank you for the question. Firstly, I'd like to state that the respondent and the claimants are two different companies. The document which has been produced, even it is a conversation between the legal representatives and the CEO of the company inside the matter. The moot proposition does not state that the legal representative is a part of the company. But however, it showcases that the respondent should not have been in possession of this document. Hence, according to the claimant, it wants to go into the purview of attorney-client privilege to state that the document is inadmissible in the court of law. If the tribunal is satisfied with the answer.
Just one question. As per your definition, does it fall under this screen falls under the category of information provided under clause 12 of your collaboration agreement? Confidentiality. Will this print screen be treated as confidential information that should not have come in public domain?
Mr. Arbitrator, thank you for the question again. According to clause 12.2, confidential information may only be disclosed to those employees, contractors, or representatives.
My question is very simple. It's a yes or no question.
Yeah.
Will it come under the category of confidential information?
Certainly, Mr. Arbitrator, it does come under the purview of attorney-client privilege, and it is a confidential document.
No, the attorney-client relationship, that is a difficulty. Here is no attorney, no client. It is your own establishment, including the within the company. So therefore it is an internal communication, not from an outside attorney.
The attorney is not party to this agreement.
But Mr. Arbitrator, as I've already stated, the moot proposition does not show whether the legal representative is from the company or outside the company. In this presume, the claimants want to say that is saying that the legal representative is from the outside counsel and this falls under the purview of attorney-client privilege. In accordance to the IBA rules of the taking of evidence in international arbitration, specifically to Article 9, Clause 3, the arbitral tribunal may, at the request of a party or on its own motion, exclude evidences obtained illegally. The claimant has made it very clear through the facts of the case that the document which has been obtained by the respondent is illegal and should not be included in the proceedings and should not be admissible in the court of law. I would like to also cite the case of Limanako Holdings versus the Republic of Turkey.
How it is illegal? How it is illegal?
How's it?
How the evidence is illegal?
How do you say that it has been illegally procured?
According to the move position, I'll just read out. Mr. Arbitrator, firstly, as I said, it is an internal document of the communication and should not be in the hands of the respondent. Firstly, on the second, the claimant has objected the respondent's submission that such document at the hearing, stating the purported document is admissible. The email communication is an internal communication between the legal team and the CA. It has been already established that the document has been obtained illegally by the respondent, and that is what the claimant was like.
No, but the statement of claim is says that as fresh evidence during merit hearing, you presented, Artificiana presented a email which was presented at a later stage of the hearing. It is with reference to the time that you were making the objection and not about the admissibility of the document as such.
The claim, thank you, Mr. Arbitrator. The claimant would like to mention the case of Limanako Holdings versus the Republic of Turkey, where the Permanent Court of Arbitration had clearly stated that all privileged documents and information which have been tendered or disclosed to the tribunal in connection with the claimant's application in February 2009, which is the date of the preliminary issue, stated that will be excluded from evidences, and any privileged documents or information which will be introduced into the evidence in further proceedings of this arbitration to be excluded as well, to ensure a fair and just arbitration procedure and to give the justice that is required by the deemed by the claimant. On the other hand, I would like to also mention the case of Shank Corroborators versus Bharat Cooperative Bank, which is mentioned on page 25 of the compendium given below, which states that even if the arbitrator is not bound by the provisions of Evidence Act or Civil Procedure Act, it cannot overlook the principles of natural justice, fair play and equity in the proceeding. As the claimant has already been stated, that the internal document, the admissibility of internal document is depriving the claimant from this right of natural justice and fairness, which lies at the heart of the arbitration proceeding. Hence,
No. What was the nature of the document? What it, which way it prejudiced your claim? Has to be also. You have to also say that. No, you have to say which way it prejudices your claim. What was the nature of that communication which was deterring you from proceeding?
yes, Mr. Arbitrator, I was coming to the point.
Yes.
I would like to also state that the document which has been produced by the respondent is completely irrelevant to the case. The document which has
So if it is irrelevant, it is not harming you.
it defies the timeliness of the arbitral proceeding. It can be just a tactic by the respondent to just delay the time for the claimant to seek its own damages.
So if it is irrelevant, why you are objecting to it?
So if the arbitrary court accepts this the document which has been produced by the respondent, the claimant is deprived of his natural justice, and the claimant does not want to take any further risk of what the allegations may arise on the acceptance of this document.
So basically, you are aggrieved by the procedural delay that may occur if you take into account this document, right? And not the authenticity of the document per se.
Authenticity of the document, but as I've already stated, that the claimant cannot take any further risks because the claimant is already deprived of its justice.
So that's what I'm saying. You are aggrieved by the presentation of this document at such a belated stage, which would be a procedural difficulty, and not really aggrieved by the authenticity of the so-called document, right?
Yeah.
Or you agree by both the aspects?
I agree with both aspects that it goes hand in hand. The respondents have reached the agreement, showcasing the lack of good faith, and the production of this document is deemed to be illegal, again depriving the claimant from the course of its natural justice. Both going very hand to hand in the it will go very hand to hand in the arbitral proceedings. The claimant should not take further risk and request the arbitral tribunal to declare the document admissible.
One question about the issue number 4 you argued on, 4 and 3 also you argued, I think, about intellectual rights. Okay, you only argued the 3. Okay. Okay. Okay.
Mr. Arbitrator, if it pleases, the question which you want to ask will be answered in the rebuttal.
Okay.
In an overview, the document which has been produced by the respondent should be declared on its deemed that it's irrelevant, it is confidential, it deprives the concept of the doctrine of clean hands as well as the doctrine of a fruit of a poisonous tree, but the evidence which has been included by the respondents is considered to be the fruit which admitting to the case poisons the whole case and deprives the claimant from the course of natural justice. Hence,
So while concluding your submissions, what relief you are taking from the
the claimant seeks that, in accordance to the arguments made by the council, it seeks that the damages of $500 million should be awarded to the claimant, as well as the document which has been produced by the respondent to be declared inadmissible in the court of law.
What is the basis of your claim of damage? How you have calculated the damage?
The damages are calculated in three aspects.
Let her answer.
The claimant would like to diversify the damages into 3 aspects. One is the contractual breaches of the agreement. Second is the extensive labor as the claimant had continued to perform its due diligence in the contract, and the showcase of good faith on the side of the respondent to provide its financial contribution, which is again in sub-relation to the contractual basis. And the third, the inadmissibility of the document and the claims that the respondent makes that the document had only contained evidence that the claimant should use updated technology. That's what the respondents wrote in the email. That was the conversation. However, according to the contractual agreement, it does not state anywhere that the respondents are focused to give technological expertise to AI innovations. However, they are only focused to give financial contributions in the project. Hence, if it satisfies the arbitral tribunal, the claimant would like to proceed with the prayers.
Please proceed.
Wherefore, in the lights of the facts presented, issues raised, arguments advanced, and authorities cited, the Council, on behalf of the claimant, humbly prays before the Arbitration Tribunal of Singapore that it may be pleased to adjudge and declare that the tribunal does have jurisdiction on this matter, thus should consider the awards passed as the final award. The challenges made by the respondents are invalid, validating Mrs. Arika Sinclair's appointment. The claimant is in ownership and proprietary rights over the intellectual property rights of Mindflare. The respondents have brought addition of losses to the claimant due to the non-performance of the collaboration agreement, entitling the claimants to seek damages. The print screen produced by the respondent is inadmissible on the grounds of its illegal obtaining and irrelevancy towards the case, and or pass any other order, direction, and relief that it may deem fit in the interest of justice, equity, and good conscience. For this act of kindness, the claimant shall duty bound pray for ever. I thank the arbitral tribunal for taking the time to hear the proceedings.
The council seeks permission to move to the dais. The council is representing the defendant in the case of AI Innovation versus Artificiana. The council would like to collectively refer the bench as the arbitrator.
Yeah.
The council will be dealing with issue number 1, 2, and 3. And
Before coming to the issue, kindly tell something about yourself. You means your company.
Sir Arbitrator, our company Artificiana is a very culturally diverse country, and we have come together in this realm of we have been approached by AI Innovation in order to collaborate in a project Mindflare.
No, but first explain who are you?
Give a background of all
Background
your
of your
company.
company.
Sir Arbitrator, we come from a country called Indovia. which is a vibrant and culturally diverse country and has emerged as a global technology powerhouse with thriving IT and software industry. We are known for our rich history and technological advancement, and we have also become a hub for innovative companies seeking to leverage its skilled workforce and vast market potential. Also, Artificiana Private Limited, it is a fortuner in the Indonesian tech landscape, stands at the forefront of this technology revolution, driving transformative solutions across various industries.
You are also in the business of providing financial support.
Yes, the arbitrator, we are. So arbitrator, if you are satisfied with the, I would like to. So the first issue before the tribunal is whether the arbitral tribunal has the jurisdiction to hear the issue. It is humbly submitted before the court that the arbitral tribunal does not have the jurisdiction to hear this issue, and this contention is sought on the following ground. The first ground is fulfillment of the pre-negotiation period. The arbitrator, if you look at clause 25.1 and extra A of the collaboration agreement, it
If you are
states
saying that this dispute is not arbitrable, then why you propose to appoint an arbitrator from your side?
the arbitrator, first of all, we tried, the person who have approached for arbitration is AI Innovation. However, we have tried our best to amicably settle the dispute through
As
negotiation.
per the arbitrator, as per appoint a chairperson. So they nominated and you also nominated. Then after nominating a arbitrator from your side, how can you challenge that?
Sir arbitrator, we wanted to amicably settle the dispute first with negotiation. However, when it failed, we appointed an arbitrator again, Ms. Stanley Hooper, and we also reached out to them. If we look at the new proposition, it says that Ms. Stanley
Who invoked the arbitration clause?
AI Innovation. Sir arbitrator. They
So
invoked-
what they said in their notice of arbitration?
Sorry, sir arbitrator.
What they requested from you in their notice for invocation when they invoked the arbitration clause? What they asked from you?
They asked for damages 500 million, and they asked for 500 million damages, and they also applied for the patent
They also
rights.
suggested you to nominate your own arbitrator. Is this correct?
Yes, yes.
And you appointed an arbitrator.
yes.
So once you also appointed, nominated your arbitrator, thereafter how can you challenge that this arbitration is bad or premature?
The arbitrator, firstly, when they approached the tribunal for arbitration, we did not want to submit to it. However, when the things escalated, we chose our arbitrator just to be on the safer side. However, when the third arbitrators were appointed by SIAC, it clearly, Ms. Erica, who is the spouse of Ms. Murray Sinclair, it clearly showed it was AI Innovation who requested the Singapore International Arbitration Tribunal to appoint a third arbitrator. Sir arbitrator, to answer your question, we appointed an arbitrator just to be on the safer side, so that if the dispute escalates any further, so we have a person who will represent us fairly. However, we did not submit to the jurisdiction of the tribunal. If your lordships are satisfied, then the council.
Are you raising an objection? Are you raising a preliminary objection to the jurisdiction of this tribunal?
Yes.
Under which section?
The arbitrator, if we look at the collaboration agreement.
No. I'm saying since the law of since the Arbitration and Conciliation Act of '96 will have come into fiction, and you are raising a preliminary objection regarding the jurisdiction of this tribunal. So you are raising a preliminary objection regarding the jurisdiction of the tribunal. Under which section?
Under clause
What clause? Section.
section section 12 of section 12.
Please proceed. Please continue. Go ahead.
You continue. Your own way you continue.
Please continue.
Yes, sir. Sir, arbitrator, my first ground was non-fulfillment of the pre-negotiation period. If we look at clause 25.1 of the collaboration agreement, it says that when any of the dispute arises between the two parties, then the matter would be settled through negotiation, and the period of negotiation that has been given is 45 days. Sir, arbitrator, The matter has been referred for arbitration on October 10, 20, for negotiation on October 10, 2022, and the said matter has been referred for arbitration on 15 November 2022. It is mentioned in para 18, para 17 and para 18 of the new proposition. Only 32 days has been expired and the prerequisites of 45 days period to amicably resolve the dispute has not been met. So on this ground, I state that the tribunal does not have the jurisdiction. My second ground is time bar clause in an arbitration. So arbitration, it is a very well recognized principle that when a stipulated period of time is given in which an arbitration has to begin and that is not complied with, then that agreement is said to be time barred. If we look at the case of Atlantic Shipping and Trading Company versus Louis Defoe and Company, this principle has been upheld and said that it was lawful to have a clause that arbitration must be commenced within a certain time, and that if it was not so commenced, then the claim would be barred. And in the same case, the arbitrator, the stipulated time period is 45 days. However, only 32 days have been passed, and the claimant has filed for the patent rights of mindflayer, which shows that which can be interpreted that they are acting in bad faith because they went behind the back of the Artificiana and they just timely filed for the patent rights of mindflayer, knowing that there was a conditional transfer of ownership that was mentioned in the collaboration agreement. My third ground is
Just a minute. If I go by what the counsel for the claimant has stated, the date of initiation of the negotiation was 1st of July. So that was the first attempt that was raised by the claimant for the purpose of reaching out to you for the purpose of, let's say, settling the dispute. So if we take 1st of July as the initial date and 15th of November as the invocation of arbitration clause, the period of 45 days was very comfortably over. How do you say that the period of 45 days was not over and it was a premature reference that was initiated or invoked by the claimant?
Sir Arbitrator, if we look at para 17 of the moot proposition, it has explicitly mentioned that when the negotiation period started. I read verbatim. On October 10, 2022, in order to put the dispute to bed, Artificiana's legal representative, Ms. Nancy Hooper, privately reached out to Mr. Steve Bayer from AI Innovation, attempting to negotiate a settlement outside of the arbitration. So, it's clear, the moot proposition clearly states that it started on October 10, 2022. And if we look at para 18 of moot proposition, it says that on 15th November 2022, AI Innovation sent a notice invoking arbitration to Artificiana. So, by this we conclude, we can interpret that only 32 days have been
Can we
passed.
have para 11 of the moot proposition copy, please? Para 11.
Yes, arbitrator.
Can we have para 11 of the moot proposition? On July 15, recognizing the potential impact of misrepresentation, AI Innovation sent a formal letter to Artificiana in this letter. So, if we take this date as the initiation of negotiation attempt by the claimant, will the period of 45 days not be exhausted comfortably? Because this was a formal letter which was issued, right?
And why in between your agreement? Because your agreement was not completely it was existing. During the existence of your agreement, why you gave a public statement that it is only you who is developing this product?
Sir Arbitrator, it was before everything happened. It was before the negotiation process happened. We do acknowledge that we failed to represent the council in the press release. However, Sir Arbitrator, as soon as we recognized our mistake, we promptly reached out to them and we rectified it and we again held a press conference and we did try to amicably resolve the dispute and we did say that they are our technical support partner.
So that means the very description of the agreement between you and the claimant is wrong. If you are saying that they are merely a technical partner, then there cannot be a collaboration agreement. Collaboration means a partnership 50-50. Once we are terming them as technical partners, then the very description of the agreement goes.
Sir Arbitrator,
You are mandated as per clause 5.3. Artificiana shall ensure accurate representation of AI innovations contribution to mind flyers in all relevant communication. Were you not in violation of this mandate casted upon you?
Sir, before addressing this issue, I would like to address the previous issue that the arbitrators raised about the initiation of negotiation on July 15, 2022. Sir, if you read the para 11, it talks about the misrepresentation. It does not talk about the breach that has been happened. It only talks about the misrepresentation.
Even if it is not a breach, even if it is a misrepresentation, by this misrepresentation of your misrepresentation, do you feel that claimant has been damaged, their reputation has been damaged?
The council have always tried to uphold the contractual agreement, uphold the collaboration agreement, and we do acknowledge that by not mentioning them at the first instance, we acknowledge that, but however, we try to promptly resolve it as soon as we got the chance.
So you admit that because of your statement, some damage has happened to their reputation.
Their claim is basically based on your failure to give the financial contributions. It's not based on, they don't seem to attach much importance to the damage done to their reputation. Rather, they are talking about the delays in your payments. Therefore, your case would be better put by saying that your financial obligations were met by you. And on that aspect, you can address us.
Sir Arbitrator, as you asked that, Sir Arbitrator, as you asked about the delay, yeah, we do acknowledge. However, Sir Arbitrator, if the damage, the time period, if you see, it was not enough for AI Innovations to suffer the damage, because as soon as they invoked that notice, we promptly replied to it and we said that they are our technical support partner. Answering your question, Mr. Arbitrator, if you look at clause 5.2 of the collaboration agreement, if you look at clause 5.2 of the collaboration agreement, it says that AI innovations can provide technological expertise, AI algorithms and innovation to drive the development of mind layer, and in return for the contribution, AI innovations can receive a financial contribution from Artificiana as specified in the collaboration agreement. The arbitrator mentioning them as technical support partner is an accurate representation, because we were responsible for providing financial support to AI innovation, and they are responsible for the technological expertise. So mentioning them as technical support partner, I think it shows our bona fide intention that.
So you are admitting that your role was only to finance them, support them financially.
According to the collaboration agreement, sir.
So and you have no role except this financial support in
No,
developing the
sir,
product. But in your statement, you have said that you are developing a product.
Sir, arbitrator, we are not only financial partners, but also we are working with market and domain knowledge, introducing the product into market. So we are also responsible for that. However, sir, the technological expertise would be AI innovation. They are merely responsible for the technological invention, and mentioning them as technical support partner is enough to give them due credit, which they deserve, And
Anyway, at this stage, we are concerned with the order, procedural order number 5, dated 15th of March 23, whereby they have, as preliminary issues, framed these 5 issues. Therefore, on the merits of your case and your contest on the merits will be addressed and considered only at a later stage. At this stage, you confine yourself to these 5 issues which are of preliminary nature. About the jurisdiction of the tribunal, appointment of that particular Mr. Erika, then claimant on proprietary rights, then breach of agreement, thereby entering the claimant to seek damages, as well as admissibility of that document. So you confine mostly on these issues which are under consideration. Your other, on the merits of the case, it will be at a later stage only, no.
So sir has raised 5 points. So to be precise, first we focus on 2 points: how you are aggrieved by this arbitration proceeding, and how you are appointment of the chairperson of the arbitration.
And moreover, you have raised a question whether the very arbitrary nature of the dispute. Your case itself is that this is not within the purview of arbitration, because it is an intellectual property right. So therefore, you address those questions. arbitrable issue because it is an intellectual property right that they are claiming. That is not to be arbitrated upon. That is your contention. You address on
So
those
why it
issues.
is not arbitrable? This our intellectual property issue is why this is not arbitrable.
Sir arbitrator, we are not contending that the IP rights are not arbitrable in the court. We are contending that if you look at the facts of the case, this is not the right time to go for arbitration because the negotiation period has not been met. The negotiation were undergoing and we have reached out and they have not reached out back to us. So the negotiations are underway. So that's why we think that this is not the right time to come for arbitration, but we should firstly try to amicably sit together and resolve the dispute. And about the appointment of Miss Erica Sinclair as the arbitrator, if we see that an arbitration is a quasi-judicial proceeding, and one of the fundamental principles of international commercial arbitration is its impartiality, independence of arbitrators during the arbitral process. It has been held in the case of Hossack Channel Dock and Elevator Company versus James W. O'Brien that an arbitrator is a quasi-judicial officer and therefore they need to be impartial, independent and freedom from, and they need to have freedom from any kind of undue influence. Sir Arbitrator, it has been argued that every action that law takes, it has a moral infliction on the entire society. So, arbitration has been described as the most ethical institution in the society. Arbitrators exercising their power should be impartial and free from undue influence. The arbitrator, if you look at the facts of the case, Miss Erica Sinclair, she is the spouse of Miss Murray Sinclair, and Miss Murray Sinclair holds 99% algorithm in a Japanese incorporated company, which in turn holds 57% shareholding in AI innovations. So there is a direct conflict of interest because Miss Erica, and also it is to be noted by the tribunal that Miss Erica Sinclair failed to mention that she is the spouse of Miss Murray Sinclair. It shows that, and it shows the principle, the most important and the fundamental principle of natural justice is rule against bias. If Miss Erica Sinclair is to be appointed as an arbitrator in this tribunal, then that rule against bias will be compromised. There is a very likelihood of bias, like a huge chance of likelihood of bias for arbitrator. So Miss Erica Sinclair should not be appointed. Her appointment should not be.
But there was a period within which you were supposed to raise this objection. That period was for 14 days. Why was that period not adhered to by you? Since all this information was very much available in public domain, there was a specific period within which you could have raised this objection, and this could have had, let's say, a lot of weightage. Once you have not adhered to that period, can we not treat it as a deemed waiver at hearing?
Sir Arbitrator, if you look at para 21 of the Blue proposition, I need that although the information about Mr. Sinclair was available on the website of data mentioned since the beginning of arbitration proceedings, it could only confirm the information that Mr. Sinclair was Miss Erica's spouse on January 4, 2023, when Miss Erica Sinclair responded to the request for clarification submitted by the respondent. Sir Arbitrator, it is humbly submitted that if they would have disclosed this information in the first place, then this delay wouldn't have happened. This is a fault on their part because they failed to mention that there is a direct connection of Miss Erica Sinclair.
When you came to know that the chairperson
On
is related to others,
on January 4, 2023, when Erica Sinclair
and when you raised the objection, after how many days after coming to know?
as soon as we got the print screen, we raised this objection for arbitration.
Moreover, you can take the stand that since Indian law will apply, Section 12 will also apply.
Yes, sir.
And she had an obligation to disclose it of her own without having you yourself to
Yeah.
point it out.
Yes, indeed, sir.
Yes, yes. So you can rely upon Section 12 also.
Indeed, sir. Sir Arbitrator, I would like to move to the third issue if the arbitrators are fully satisfied with my first and second issue.
For third issue, okay.
Third issue is whether the claimant has ownership and proprietary rights over the intellectual property rights of Mindcare. It is also submitted that they do not have the intellectual and property rights of Mindcare, and the first ground is breach of good faith. The arbitrator, Artificiana has always tried to acknowledge the clauses that have been mentioned in the collaboration agreement. It is of utmost importance to us. And if we look at clause 20.1 of the collaboration agreement, it says that upon the completion of the project, the intellectual property rights will be transferred to artificial.
But can you read clause 20.1?
Yes, Sir Arbitrator. Clause 20.1 says that it would be transferred to artificial upon the successful completion of the project.
So, till date it is not complete.
Sir Arbitrator, if you look at the facts of the case, Artificiana AI innovation did not, first of all, AI innovation did not deploy the updated technology to make Mindflayer, and also they put forward a financial standing that they were not in the position to hold. They misrepresented AI Artificiana and they lied about their financial standing. Also, they did not employ updated technology, which can be interpreted that it was never their intention to complete the project in the first place. It is a very established principle of contract law that parties to a contract, and it has been held in case of Washam and INC versus Township of Middletown, that parties to a contract must act in good faith, which includes not engaging in actions that undermine the essence of the contract. By not stating their proper financial standing and by not deploying the updated technology, it can be interpreted that they have acted in bad faith, because it was never their intention to transfer the patent right to, which is a violation of 20.1. Also, Sir Arbitrator, it is to be noted that it was AI Innovation who approached Artificiana to enter into this collaboration agreement. Also, Sir Arbitrator, when the negotiations were undergoing, they clandestinely applied for the patent rights of Mindflayer. They went behind our backs and they applied for patent rights. When there is an explicit completion of clause, until the completion of clause, there is an explicit mention that when it will be completed, there will be a transfer of ownership rights of intellectual property. So it can be interpreted that they have acted in bad faith, they have misrepresented us, and also the arbitrator, it is said Artificiana would have never entered into an agreement with AI Innovation had they known that they don't have that updated technology to make Mindflayer, and had they known that they do not have the proper financial standing that was required to make the project Mindflayer.
No, but you had never raised any such a dispute about their abilities.
Sir,
The whole dispute started with your representative, your chief executive making statements in public without giving due credit to the contribution of your partner. That was the grievance. You never started making the allegation or say that the opponents do not have. They don't possess the technical know-how to make this Mindflayer. So that kind of an argument, which is not born out of the facts, that would be a problem.
yes. Sir Arbitrator, it's humbly submitted that the council asserts that we have always tried to uphold the contractual and collaboration agreement. We have never wanted to end this or terminate this. If we would have wanted that, we would have sent a notice for termination according to the collaboration. But we did not. We always want this contract to upheld. We have always respected the contractual agreement. But when they went behind our backs and they designedly applied for patent rights, when they went behind our back and clandestinely applied our patent rights, it forced us to come and finally address everything that has been written. Also, the claim for 500 million is absurd and erroneous, Mr. Arbitrator, because there is no misrepresentation, there is no wrong information that has been given to the public, because referring them as technical support partner is giving them their true credit. With this, Sir Arbitrator, I complete my speech.
Just one question for you.
Yes, sir.
20.1, one word. Retain. What is your understanding of shall retain in consideration of services rendered and any payment made under the collaboration agreement? AI Innovation shall retain all rights to any intellectual property. They would be able to retain once they apply for it. How can you say that they have made an error by applying for the IPR? They would be in a position to retain this IPR once they have applied it and once they have procured it. Until unless they have not procured it, how will they retain it? How are they wrong in applying for the IPR?
Sorry, sir, I did not understand.
The word retain is there, right? Retain would come into the picture once AI innovation actually procures the IPR. You are saying that you are agreed by the action of AI applying. Application is number one, grant is number two, retain is number three. When they have the right of retaining it, how are they
Yes.
at fault in applying for it?
Yes, indeed, sir, arbitrator. However, sir, arbitrator, it is to be noted that AI innovation is exclusively applying for patent right. That means that they are not upholding to the contractual agreements. They are applying for permanent patent rights.
So you're presuming that they would not transfer it. That is
Yes,
a
because they
presumption.
have already applied, sir, arbitrator.
They
They
would-
have already.
The word retain is used here, right?
Sir, arbitrator, if you look at, yes, sir, arbitrator, they have breached this 20.1 because they have clandestinely applied for exclusive rights because it was written that until the, after the successful completion of the project, it will be transferred. But what they did was they went behind our back and they applied for permanent patent rights. Means it will not be transferred now. It will be in their hands if it is granted. So that can be interpreted as acting in bad faith with having malified intentions.
But you will have the right only after making them the entire payment. Why you are not making payment to them?
Sir,
Why you are
arbitrator,
not making payment to them?
Sir, arbitrator, that could be dealt by my co-counsel in detail. However, I would just like to firmly point it out that there is no mention of not making timely payments in the moot proposition, and the council firmly asserts that we have cleared all the payment, we have made all due payment that was required. With this, I conclude, and my co-arbitrator will be dealing with 4 and 5 and elaborate on the slide.
Council seeks permission to approach the dais. Council seeks permission to commence issue 4. Issue 4 deals with whether the respondent has breached the agreement, thereby entitling the claimant to seek damages. It is humbly submitted before the Honorable Tribunal that the respondent, that is Artificiana, has not at all breached the collaboration agreement, and therefore AI Innovations is not entitled to seek any damages, and this is being sought on the following grounds. Firstly,
Their allegation is twofold. Their first allegation is that in view of 20.1 clause, the intellectual rights are missing. Your company is only providing financial support to them. So you cannot claim that you are developing some product. Second is their allegation is that you are not making the payment. You are not making their due payment.
indeed. So firstly, Sir Arbitrator, it is about misrepresentation. We are asking for accurate representation, which we did not do apparently. And second is about timely payment. So, Mr. Arbitrator, I would like to point out that when it comes about, there is a clear mention that there has been an oversight from our part where we failed to mention them, where our CEO failed to mention their collaboration. However, there was no mention in the entire moot proposition that they even excluded them. It was just that there was no mention of it. And, Sir Arbitrator, coming to your second
But
point.
your non-mentioning their name has brought huge loss to them by way of loss to reputation.
Indeed, Sir Arbitrator. However, this is also a mere claim for that side. There is nowhere in the fact proposition or any proof that they have actually incurred any losses. There is no way that any company has actually come to them and they have been rejected just because of the fact that we, the council, our party has in any way abridged that portion. And Mr. Arbitrator, I would also like to reiterate, my co-counsel did, that as soon as this was intimated to us, the respondent clearly and very immediately, promptly replied to them and acknowledged the mistake. And in that mistake, again, they did have a problem with the fact that we call them technical support partners, which they were not happy with. Even then, we immediately responded to them after they shared the grievance with us, and we tried to come in terms with it. I mean, rectify our mistake, acknowledge it. However, we, according to the moot proposition, we were facing internal delays, and also the 45-day period was not expired. So we were at least expecting that within 45 days period, there is a total probability that we would have done something about it, Mr. Arbitrator. And Mr. Arbitrator, you question about the intellectual property rights. I would like to read collaboration agreement clause 20.1 that says that this clause explicitly addresses intellectual property rights. It stipulates that AI innovation will retain ownership of the IPR until the completion of the project. I request the arbitrator, Mr. Arbitrator, if you may refer to the moot proposition where it all started, that is paragraph 9 of the moot proposition. So in paragraph 9 of the moot proposition, it was first when the interview happened. In para 10, there was an oversight which we acknowledged. They again had a problem in the same para 10 that we referred to them as a technical support partner. In para 11, we again redressed that issue, and in para 12, they said that okay, it is acknowledged, but however it is not rectified. After all of this, if we turn to page number 5 of the moot proposition and see para number 17, that is when their legal representative, Miss Nancy Cooper, approached us, and when she approached us, we told them that we will not apply for the patent rights and we will just retain the rights as it was according to the agreement. So we even rectified that, Mr. Arbitrator. And it was only after that, after failure of so many attempts, that if in page number 6 of the moot proposition, line 3, first, second, third line, that is when AI innovation further claims that Artificiana has not made timely payments. So it is clear from this, it is hinting that they have an intention of clandestinely going behind our backs, applying for the patent rights, and all of this DDA and all of these contentions are actually only being raised because they want the IPR rights all to themselves. When this proposition clearly speaks about equitable sharing, firstly they will have the rights, and upon the completion of the project, we will get the rights. We have not hasted anything. We have not hasted any procedure where we have retained any documents or not helped them with this. Mr. Arbitrator. A case to support my argument would be KSR International Company versus Teleflix Inc. In this case, the US Supreme Court held that IPR protection should not be granted to innovations that are mere obvious modification or existing inventions. So when this AI invention and Artificiana came in together and collaborated on making this act called Mindful, it was a shared thing. Now they cannot just go and claim it all to themselves and snatch all our hard work and everything just because of few delays. There was no intention from our part to terminate the agreement which is being reiterated by them. We just wanted to come to the arbitral tribunal and sort out certain disputes.
Under which law you say that you have the proprietary right on the instrument being produced by them?
The agreement itself had provided that at the conclusion of the project, it will be transferred to you. The intellectual property right will be transferred to you when you complete the payments and the project is completed. So therefore, you were the actual person who were entitled to the final product of Mind Flare.
Indeed, Mr. Arbitrator. However, the problem here with us is that they went behind our back. They acted nullifiedly. There was malice because of everything. All they wanted was actually to get the right. Maybe they were not happy with the fact that we are going to get it later on, because if we see according to the moot proposition, there are constant delays, delay after delay, and after that there was a claim, just a claim and mere claim that there was no timely payments on our part. There is nowhere mentioned here that there is a not a timely payment.
So your only apprehension is there. Your apprehension was there that after they register their patent, they will not transfer that to you.
No, sorry, Mr. Arbitrator. What I am trying to put across is that they wanted to apply for permanent IPR rights, meaning they wanted exclusivity over it, and they wanted to retain it. So they are saying that
Where in the agreement it is written that in between they will not register their patent.
indeed
They will not apply. Is there any bar in the agreement that they will not apply for the patent right? Unless they apply for the patent right, how can they transfer that to you?
Indeed, Mr. Arbitrator. However, I would again like to reiterate that the 45-day time limit, I think we should have been given a minimal time limit for us to actually function. And the issue itself talks about it. For example, if we would have gotten the actual time which we well deserved, there is a probability we would have done something about it, as our team was already working on it, and it was clearly made clear to them that we were facing difficulties. It was not like the other party was not intimated about the same.
What were the difficulties being faced by you? What were the difficulties being faced by you?
We were having internal conflicts on as to we were having conflicting opinions and
Internal conflict with whom?
our team.
Your own team, not with the claimant. So why the claimant should suffer because of your internal dispute?
Indeed, arbitrator. However, if it was after the 45-day period, we would have stayed silent on this, and even the new proposition gives us this for the collaboration agreement. If it gives us this 45-day period, we would at least request or like it that they waited for this period. They waited it out.
So after your internal dispute, a new management comes and they give a declaration contrary to the agreement, is that fair? And why should you not suffer damages for that?
Indeed. If arbitrator, they're talking about delay in payment which happened because of because we delayed and we were facing internal conflict. They claim that because of that they have faced payment delays. However, that was only a claim that they are facing payment delays. And if we look at the next issue that I'll be addressing, that is that talks about the print screen, that they are saying that should not be.
No, before that, is there any time frame which was mentioned in the agreement about the payments and the quantity of payments to be made to the opponents? See, their claim is based upon your failure to pay the money. You want time. For that matter, they have to establish that the agreement contemplated a time frame within which money is to be paid and what is the amounts to be paid. What that there any discussion or any clauses in the agreement providing for payments. That aspect would have to be emphasized, because without a time frame being mentioned in the agreement about the payments to be made to them, you cannot be accountable for delaying payment. See, I am saying something which is, on to the root of the matter. If there is, unless there is a time frame for making the payment, you cannot be tagged with the default clause. There is nothing mentioned about the time frame, I suppose.
It is silent.
Now you were talking about a short screen, that the internal email. How did you come by that document? They are themselves saying that it is an inconsequential document.
Indeed, Mr. Arbitrator. Firstly, I would like to address the latter part of your question. That is, they are saying that it is insignificant. However, the entire claim of the fourth issue that we have delayed payment was because we do not have updated technology.
Okay, explain what is this email? What this email talks about?
Indeed, Mr. Arbitrator. So this email has been presented by the respondent on 4th of June. And when the proceedings were already going on, so this is basically in the ongoing proceeding, it is an email, it is an internal communication between Mr. Bryers, that is the lawyer of legal representative, of AI communication, AI innovation, and their CEO. That is that is an internal communication between them that has been cited here. But there it has two things that has been mentioned about. Firstly, Mr. Bryers has spoken about the conversation that Mr. Bryers had with our legal representative, that is Miss Nancy Cooper. And secondly, that Artificiana had requested for updated technology time and again from our opponent, which is why.
Is that request a part of the agreement?
No, Mr. Arbitrator. However, there was no updated technology.
See, the objection about this document are twofold. One is that as fresh evidence during the hearing of the merits. So therefore, what the first question is whether admissibility of this document because of the delay in presenting that document itself. According to you, was it presented on time, or the delay is to be condoned, or it is admissible, not inadmissible on account of delay? That is one aspect. Second aspect is how did you procure it? So if these two things are addressed, we will be,
Indeed, Mr. Arbitrator. So firstly, it is asserted that this print screen that we have presented was shortly acquired before us, the hearing, and this timing aligns with the respondent's discovery of the evidence. When we discovered this evidence, it was the very last moment. It was not like we already had this evidence and we waited for the last moment, Mr. Arbitrator, and it is crucial for our case, because if they get to prove that, if we prove that we have incessantly asked for updated technology, their claims of payment become null, because then the agreement is on that part that we will make the payments, and in return they will also give us something.
There are two contentions that were raised by the claimants. Number one was the time framework wherein which this document was placed before the tribunal. The second is the manner and the authenticity of the documents. The first aspect you have submitted your submission. What about the second aspect? Fruit of poisonous tree. What do you say about that?
Indeed, Mr. Arbitrator. I would like to refer to Rule 19.2 of the SIEC Rules 2016 that says that the tribunal is vested with the authority to determine the relevance, materiality, admissibility of all evidence. By saying this, I just want to reiterate that our respected honorable tribunal does have the right to, if it wants to determine this thing. And I would like to refer to the case of Ras Al Khaimah Investment Authority versus Azima, where the Court of Appeal considered whether email correspondence obtained by hacking could be admissible at trial, and it concluded that it was. In another case, it is a recent judgment of the Supreme Court, that is Yashwant Sinha versus the CBI. In that particular case, what happened was there were certain documents that had been acquired secretly or illegally, basically, and then the Supreme Court held that the Supreme Court may penalize them for that acquired, but because that particular information that was there in the document is crucial to the decision of the case, Mr. Arbitrator, they would have considered it. Hence, our plea is that Rule 19.1 of also this SIEC rules, it says that in conducting the arbitration manner that ensures fair and expeditious resolution, and there will be some sort of transparency here.
There the problem is that they are talking about the confidential nature of that document. If the document in itself is not a confidential document, it is very much admissible. So therefore, you have to rebut that argument that it is not a confidential document. Rather, it is a usual internal document that can be looked into.
Indeed, Mr. Arbitrator. So, if we refer to the IBA rule that is probably being referred from our respondent side, Article 9.2b clause talks about this, that it may be excluded, and it may be excluded if it has something to do with professional secrecy, attorney-client privilege, or without prejudice. However, this attorney-client privilege that was being contended by the claimant does not seem fit, because it is some sort of communication that is internal. Attorney-client privilege, Mr. Arbitrator, comes into play when two parties are involved and when two parties are in tandem with each other. Also, Mr. Arbitrator, I would like to...
Negotiation and contract are two different things. So, is this email in the category of negotiation or a contract?
It's only an internal communication addressed by the head of the legal team to the chief executive of the company. So therefore, it is strictly speaking not that of an attorney as well as an independent advocate and a client. So that to that extent, that document may not be a privileged document.
Mr. Arbitrator, if we see that, again I would like to refer to Rule 19.2 of the SIEC rules that we already did. This rule reflects that the flexibility and adaptability of the arbitration process. So here, maybe materials that might not be admissible in a traditional courtroom setting are highly pertinent to this arbitrational case, so that it would be tailored in a sufficient way that in case there is maybe mistake from our part, should I
Continue.
so, Mr. Arbitrator, even if there is a breach, not a breach, but if any discrepancy from our part, it would not nullify the entire case. However, because of the merits of this particular point, we are at least given a chance to proceed further, Mr. Arbitrator. And
What is the benefit you will get if this email communication comes from the court?
Mr. Arbitrator. Mr. Arbitrator,
What was the substantive content of that email which helps you in this way?
it helps us in this way, Mr. Arbitrator, that there is a request, meaning the claimant's legal representative, that is Mr. Byers, tells their CEO, that is AI Innovation CEO, that Artificiana, that is us, the respondent, have requested again for updated technology. So, if we have really asked for updated technology and we have been failed to give that, so it would prove that there is a relevancy in this part.
It's only a request, not an agreement. It's only a request. This email, by this email, you are saying that a request was made. So it is not an agreement.
I mean, Mr. Arbitrator, the request was, they were talking about it, that Artificiana had again made a request to them, so that give us the updated technology. According to the main collaborative agreement, it was decided that Artificiana will help or give in financial contributions and knowledge domain, and also integrate into the real world finances.
Suppose if they agree to give you updated information, updated technology, so then they will enter into a fresh agreement with you, and they will ask you additional payment for that.
The agreement did not specify any kind of technology, isn't it?
Indeed, Mr. Arbitrator, however, it talked about AI, algorithms, and technological expertise. So, because this is a AI system that actually talks about finances and it gives us financial analysis. If it is backdated, a lot of people would not want to come and use this AI because it is not updated and not up to the mark. There are constant updates in this.
If in 2015 I enter into an agreement with you to manufacture a particular machine as per the latest technology, then after 5 years, obviously new technologies will come. So unless the parties enter into a fresh agreement to include that updated technology, so again additional financial resources will be required for that.
No, probably your communication, that Indian communication would go to establish that there was a rethinking about the merit of the claim of the claimants because of their obsolete technology and your demand for a later technology. So to that extent, it helps you to say that what they were providing or offering is not the latest technology which would have commercial value.
Mr. Arbitrator.
For that, then I think that concludes most of your points. Now they can say in their rebuttals something, then you can also.
Mr. Arbitrator, I would like to proceed with that.
Oh, okay, proceed.
In the light of the legal precedents and principles cited and arguments advanced, the defendant most humbly prays that the arbitral tribunal may declare that the arbitral tribunal does not have the jurisdiction to hear the dispute, declare that the challenge which is raised by the respondent over Ms. Erica's appointment is moot, that the defendant does not have the ownership and proprietary rights over the intellectual property rights of Mindflayer, that the defendant has not reached the agreement, thereby it does not entitle the claimant to seek damages, and lastly, that the Prince claim which has been produced by the respondent at this stage of hearing is not admissible, and pass any order, other directions or relief that it may deem fit in the best interest of justice, equity, fairness, and good conscience. Thank you.
The first question from you, whosoever is ready. Why you applied for patent right in between?
Yes, Mr. Arbitrator, to answer the question. First of all, the council would like to say that the respondent has acknowledged that the respondent has acknowledged that he applied for patent. But this is not a true contention, as a computer algorithm doesn't fall under the content and under the aspect of Patents Act. As it is an algorithm per se, it falls under the Indian Copyright Act. Furthermore, it has been mentioned nowhere in the moot proposition that the claimant has applied for patent. If you may refer to page number, if you may refer to paragraph number 15 of the moot proposition. In this, the way the moot proposition has been worded indicates that there is no assurity that the claimant has applied for patent. I'll be emphasizing the words which indicates the following. The AI innovations internally evaluated their options and considered potential measures to protect their interests and ensure proper recognition. This evaluation included discussions about the accelerating development and marketing of Mindcare to assert the ownership and showcase their contributions independently. They started exploring their options for securing patents and intellectual property rights to assert exclusive ownership. All these 5 words indicate a room for doubt, and there has been no exclusive confirmation. Even more further in the next paragraph, it has been mentioned soon thereafter, artificial and court will a compelling industry rumor that suggested AI innovations might be applying for patent applications for Mindcare. Now again, these following words have again placed emphasis that there is no confirmation. Even further, the article that has been published by the magazine that says that we had applied for patent, even that was based on providing subtle confirmation. The article certainly explored the implications of AI innovations, potential patent endeavors.
No, but the point is that you decided to issue notice for damages, and you decided to terminate the contract, and therefore until the payments are made and the project is completed, there is no question of you are transferring the rights to the opponents. So therefore their attention that you were trying to get a patent for the product is well founded. Can you deny that then?
Mr. Arbitrator, as I mentioned, the computer algorithm doesn't come under the Indian Patent Act, as it comes under the Indian Copyright Act.
Therefore, the another aspect is that whether it is a arbitrable issue at all, because in a case like this where intellectual property rights are involved, you have to tell us about the arbitrable nature of an intellectual property right. What is the law on the subject of arbitrability of an intellectual right? What that you can say something.
And especially after when there is a specific clause 20.2 which says that after completion of the product you will transfer that product to them. So why this patent right offered by you?
So prematurely you have terminated the contract, you proceed to register it in your own name, and thereby not giving them the right which is an option to purchase it from you. And moreover, you see, you have to draw a distinction between the right in personam and the right in rum. Whatever you just explain to us what is the concept of right in rum and right in personam. Because in intellectual property rights, in arbitration particularly, the question is if it is a right in personam, it is a way amenable for arbitration. If it is a right in rum, it can be only an ordinary civil court where you can agitate. So on that distinction you can say something, because the time is also running up. You have to focus on this, because at least we will be satisfied how much you are aware of it.
Indeed, Mr. Arbitrator, since there have been 4 questions posed, I'll be answering it one by one. Firstly, the respondent has themselves acknowledged that the intellectual property can be arbitrated under this particular matter in their contentions. Furthermore, this question has been a long-standing confusion in various judgments, and this is on the basis that if an intellectual property right matter has been arbitrated, it goes against the public policy of India. Now, the council would like to state the case of forced shipping.
Before coming to the case, kindly tell us, as per the agreement,
Yes, Mr. Arbitrator.
do you have a joint ownership right on the product, or you have the sole ownership right, or the respondent have the sole ownership?
So the claimant believes as of now the claimant has the sole ownership rights over Mindflayer because as I mentioned in my contentions that until and unless all payments are made that are due under this particular obligation, artificial AI innovation shall hold, AI innovation being the claimant over here, shall hold all rights regarding the IPR of Mindflayer. And in the move proposition has been clearly explained that the financial obligations are yet to be completed by the respondent. And even further, the reason why this clause was inculcated into the contract was to safeguard the development of the Mindflayer by the claimant so that they would make the payment later on once the project is completed. Mr. Arbitrator, to further answer other questions, the council has been merely stating that it was only merely a financial obligation. But Mr. Arbitrator, that was their only main obligation in the contract. And just by using the term merely, it does not diminish the obligation of the respondent towards providing financial obligation, as it is a fundamental part that funding towards a project is required. Furthermore, the council mentioned the allegation of fraud and misrepresentation that has been done by the claimant. By no way we are accepting these allegations, and by no way accepting these allegations, we are contending that under Section 19 of the Indian Contract Act, which has been provided in front of you in the compendium, it mentions that in case of fraud or misrepresentation, there establishes a duty on the basis of the person who is alleging that to do their due diligence. In this case, we are contending that they haven't done their due diligence in a particular dispute, as in this particular collaboration agreement, and even when the dispute and the collaboration agreement is of such
Which
major.
kind of due diligence? Which kind of due diligence?
To ensure that whatever facts we are presenting in front of them is true or not.
No, the point is you started the dispute with them by pointing out that they did not give you the correct position in the whole project. That was your grievance. You never raised an issue regarding the delayed payments. And now you are at a later stage coming out with the argument that the entire output will be ours. It is patented in our name. And it was their delay in making payment which resulted in our or it resulted in breach, and therefore you are going for arbitration. So that is contrary to what was in the correspondence and various events which took place.
Indeed, Mr. Arbitrator. Mr. Arbitrator, like we stated, the first instance of the dispute was when they inaccurately represented the claimant, whereby they mentioned technical support.
That's right, that's right.
Yes. So, but from there, it has been a downhill of failure of them to meet their obligation under the contract. Thereby, it is not impossible that after this particular instance, that the other events might have occurred.
My
Yes.
question, sorry, sir.
About the arbitrable nature also you have you are saying that it is within the purview of arbitration. This intellectual right of intellectual property right. This is patent right. If patent rights are involved, Patent Act itself provides for certain kinds of remedies. So therefore, are you saying that it is an arbitrable issue?
Sir, regarding whether it's an arbitral issue, I would like to state the public policy of India. This goes against the public policy of India. This term public policy, as per the judgment that I was about to state, mentions that there needs to be a wider expansion of the term public policy of India to accommodate foreign cases in this particular instance. For example, the basis of enforcement of an award is made under Geneva Convention and the New York Convention. Therefore, the variability.
No, we are not on that issue now. There is no award. We are only at the stage of a preliminary issue of maintainability of the claim itself or the arbitration proceeding itself. You have to say that this is a right in personam. It is a right arising out of parties' interest, and therefore it is a matter to be arbitrated. And therefore it is not outside the purview of arbitration. That is your contention. Okay.
Yes, Mr. Arbitrator, like you mentioned, there are certain conditions for determining whether the dispute under IPR comes under the arbitration jurisdiction. First is that it should not oppose the public policy of India. Secondly, shall not cause any third-party problem or grievances. And like we stated, right in persona or right in rem.
Yes.
Yes. So in right in persona means the direct ownership towards the property, and the concise definition of rights in them means the indirect relation to the property that has been claimed.
The right in rem means right against the whole public, against the whole world. That is right in rem. Such an issue cannot be arbitrated. So therefore you have to say that your right is something which is a personal. It is only with reference to the opponent.
Yes, so Mr. Counsel, I was
So
about
therefore to that extent you are justified in invoking the arbitration.
Mr. Counsel, yes, Mr. Operator, yes, I was about to get to that point that it was in right in person as the claimant is contending that they are the original owner of the product called Mind Flavor. If I may clear the doubts of the arbiter tribunal.
So one more question for you, Mr. Operator. It is my understanding that your application before the appropriate authority for registration was premature. Reason being that your right to get that application registered would have accrued once you would have terminated the agreement and terminated it, stating that since they have not made timely payment, hence you are terminating that agreement, and that termination was not challenged. Then you would have the best of going ahead and filing appropriate application for purpose of, let's say, getting that patent registered in the favor. Was it not a premature action at your end?
Mr. Arbitrator, in this proposition, no one mentioned that the claimant has terminated the whole agreement. First of all, so as a result, like you mentioned, the effective resolution for the claimant is to apply for the specific resolution for getting IPR rights of Mindcare, which shall be under the Indian Copyright Act, and this has been emphasized in the case of Microsoft Technology LLC versus Assistant Controller of Patent. It is a 2023 judgment. In this, it was held that inventions to be a computer a program per se solely due to the presence of instruction shall not come under the definition of IP. That is the Indian Patent Act.
But was your application not premature?
What was the application?
Was your application for seeking registration of the patent not premature?
So, Mr. Arbitrator, that's the point that I made by referring to the note proposition that we have not applied for patent as of yet. It was only a contention and allegation from their side. Thank you much appreciated, Mr. Arbitrator, and thank you for your patience and your time.
Would you like to say something?
Yes, yes, the arbitrator.
He's saying it is only an allegation that they have not applied for the patent.
The arbitrator, to address this issue, I would like to say that all of these things happened. All of these things happened because of a column in the media. The arbitrator, if you look at para 16 of the moot proposition, it says that artificial upon built of the compelling industry, human and the AI innovation might be applying for patent right of application of mind flare, and the column was an arm wrestle titles grapple for supremacy. It all started with the column. They have been relying in editorial columns and coming to us and seeking damages of 500 million, and when we relied on a column by a scheme A and we interpreted that they are applied because, sir arbitrator, they are the first one who have relied in an editorial column. After that we followed because that was the only source that can be interpreted that they have applied for patent. Also, sir arbitrator, answering their claim, they said that patent rights, they have not applied for patent rights, and according to Patent Act 1970, patent cannot be paid. Technology cannot be patented. However, according to Section 3A of Patents Act 1970, it says that if there is a technological innovation and there is any discrepancy in that technology, and if a person applies their own mind and tries to settle the discrepancy and comes up with a new innovation, then that can be patented. Also, sir arbitrator, I would like to say that when Nancy Hooper reached out to them, they did not deny it all. They just agreed to some other terms, which shows if they had not applied for patent right, they could have just said, and the matter would have ended then and there. They could have said that we did not apply for patent right. However, they did not do so. What they did was they choose to go for arbitration even without the fulfillment of negotiation period. And as sir arbitrator, you have already said that patent rights are right in rem, and it is not right in personnel, so it cannot be granted.
No, it is not arbitrable.
It is
Because
not
we we are considering at the preliminary stage. We are not considering adjudicating the merits of your claim or their claim or your defense. We are only saying at the threshold to go whether this arbitration is maintainable at home. So it is on those lines that you have to address, because it is to be very objective. It's a preliminary stage for the proceedings.
Indeed, sir. Indeed, sir. As you said, that cannot be arbitrated. So with that, I conclude my proceedings.
Okay. So, claimant. Okay.
Okay, okay.
Yes. Give any feedback to our teams?
Pardon?
Any feedback for the
Oh, yes. You have both of you have done well, very well. But you should be very objective, because when we are not here to decide when the case which you are presenting was not considered a final adjudication of your claim and defense by the respondent. It was a case of a preliminary nature where before going to the evidence of the case and determining whether you have merited your claim, we were trying to, you were at a preliminary stage to decide about the very tenability of your claim before the arbitral tribunal. It was on the jurisdictional issues. So what jurisdictional issues when you are addressing, it is not about the merit. Of course, facts will have to be stated, but nevertheless, as I told you, have to basically whether this was a case arising out of an intellectual property right. So what is the law relating to arbitrability of an intellectual property rights? There are half a dozen judgments. So that there they have made a distinction between what is right in personam and right in rum. That's a very important legal concept. You have to study that. And with reference to that only, you could make that point that this is not arbitrable at all. Whether it is tenable or not, in the light of some of the Bombay decisions and all I was checking up before when I was looking through the webpage. They were saying that this, since it is a agreement between two parties, it's a personal right. So to that extent, a distinction can be made between personal right in personam and right in rum. So therefore, such a final legal distinctions you must keep in view and present your case. Okay. So therefore, your performance have been good. I tell you, very promising, very good. Congratulations.
Both of you did well. Both the teams were exceedingly
Yes,
well.
yes. You did
Both of them
well.
did exceedingly
You
well.
did well. But,
I will just add one thing, because in arbitration matter, the dispute was of jurisdiction also, and in CPC also jurisdiction clause is there. But that section 20 and this jurisdiction clause are totally different.
And both of you should have worked on section 16 of the arbitration clause. Section 16. Because that would have been, that was my query to you. Section 12, that section 16 deals with the jurisdiction.
and one particularly when you were told that as far as the respondent is concerned, they are governed by the Indian law. The Arbitration and Conciliation Act of 1996 is very important, particularly with respect to section 12, obligation to disclose your involvement with any of the parties. That is a very important issue. There are so many decided case laws also on that.
Well, one is the obligation casted upon the arbitrator. 12.5 is the right available to the party.
So all these things, you should, when you are preparing, you should know the nature of the legal principles which are applicable, and even this Singapore arbitration regulations also provides that arbitrator has to disclose what the interest is. It's a claim, and moreover, what basic fundamental administrative law principle. Justice should not only be done, but it should appear to have been done. Here is a case where the arbitrator is the immediate spouse of one of the claimants. How will you say that that person is not prejudiced? She cannot be. She may be absolutely impartial, but law will presume. Law will presume that such a person will be biased.
She is directly hit by 12.5. Have a look at 12.5.
So
Directly hit by
therefore,
12.5.
these things are very important. You have done well, and as you advance in the profession, you will certainly study all those things. There is nothing to.
Thank you.
We are
Thank
happy.
you. Wonderful time. All the very best.
Yes, yes. We are very happy with your.